I am Scott Collins. My law firm is Elder Law Guidance. When we're talking about VA benefits as a VA attorney, the data that I'm talking about is a federal benefit. It's applicable across all jurisdictions. So it doesn't matter if you're in Oklahoma or West Virginia, all of that would still apply to you. I'm not wearing my lawyer hat, giving you legal advice. You can never replace what I say in a webinar with an actual face-to-face, one-on-one consultation. There are so many things that change. And if we don't have the ability to dialogue and dig down deep enough, and I wouldn't want you to make a mistake or make an error by trying to rely upon something tonight. But I will try to be as accurate and applicable to your context if you want to share details. I'm happy to do that. A little bit about me. I'm former military. I was honored to serve in the U.S. Army. I have three daughters, so none of my daughters have served, but my father, my uncles, my great great grandfathers, far back as I can go, we've been service members. I also was a full-time minister for about 2 decades, so I served Protestant churches everywhere from Hawaii to New Hampshire. And there were some things in my life that had to change that were beyond my control. So that's when I entered law, knowing exactly what I wanted to do because I'd helped people in death and dying situations all of my career. I'm an educator at heart, so I thought, oh, this is a great fit to do elder law. And as soon as I finished law school, headed that direction, and I've elder law section at our state bar. I educate other attorneys across the state, and in fact, across the nation. I belong to two large uh, networks of elder law attorneys, and am active training across uh, the country. Another thing I like to do, you can see from the two pictures there, historic homes. I have 5 historic homes in the county. And I believe we much a product of our past, whether we like to admit that always or not. I got a very, very team. And in fact, that's not all of them. I need to update with a couple new faces there, but that's the firm behind the scenes. You see there at the bottom. This is the kind of stuff we do. I can't help you with your divorce, your bankruptcy, your DUI, but I can help you with your Medicaid planning, your probate, your estate planning, your veterans benefits. Those are what I specialize in. Wartime periods and their widows should not have any need, and they should always be taken care of in their time of need. So when I use this term wartime pension, it causes two areas of um, confusion. Most of us think about pension as retirement. We're not talking about a retirement benefit. We're talking about a military service member served active duty who is entitled to this benefit because they were on active duty during a wartime. They didn't have to be in theater. Doesn't matter if you were in Germany, Vietnam, you still qualify. But the reason that this is such an overlooked benefit available is that only 7% of all of the veterans that are eligible ever do apply for the benefit. And then often what I find is that you may have gone to the VA hospital, something like that. You talk with them and you say, look, what do I qualify for? And they look at this thing, wartime pension, and its categories. You may have heard it referred to as aid in attendance. And then they'll tell you, as soon as they ask you your income, that you don't qualify. Well, of course they tell you that. It is their job only to tell you, do you currently qualify, yes or no, but not how to qualify. That's where I come in. So that's what we're talking about tonight is wartime pension. If you serve during any wartime period, and I'll get to those in just a minute, you have to meet these three categories. The basic eligibility is active duty service. Now, unfortunately, that means reservists and National Guardsmen do not qualify unless they were brought up on federal orders. And those orders, of course, are under federal orders when you're at basic training, for instance. But this has to be active duty service beyond training when you were on federal orders. So, beyond that, it has to be honorable service. Now, if you have something like a general discharge, medical discharge, anything else other than dishonorable, you can still qualify with a change to your DD 214. So other than the Army, Navy, Air Force, Marines, Coast Guard, National Guard, if federalized, Space Force would qualify in these circumstances. So that's the basic eligibility, the military component. Now, after you have a military component, there has to be service time requirement. So other than people after 1980, all you had to do is serve 90 days. Only one day of that 90 days active duty had to be in the wartime period, which we're going to look at next slide. So if you served during the wartime period, 90 days active duty, only one of which had to be in that period, then you qualify. Now, if you're post 1980, then what you had to have done is served your entire contract period, whether officer status under contract or enlistment period. Now, your enlistment ended early, let's say, signed up for 2 years, and it was all in Iraq, and they said, we're going to let you go home at 18 months. As long as you served and they moved the service period shorter, you still qualify. If you had a longer contract for 4 years, for instance, in 1980 and afterward group, all you had to do has have served 2 years of the full period. That does help a lot of guardsmen, though, because you could have been federalized for that period of, let's say, 2 years back to back tour, something along those lines. So it's a little bit a different situation if you're post 1980. And the next thing is regarding the period, if you're in the 1980 and afterward, the pit is still open. It hasn't closed yet. Congress nor the president has ever closed the current wartime period because since 80, we've been in some sort of conflict somewhere, almost stop. So the Gulf War era is still considered going on, and like it will be for quite a while still yet. So these are the wartime periods. Probably no World War II people out there, though I've had the honor of qualifying them. I don't see many anymore. Mostly it's Korea and Vietnam era. But there are two categories. If you're looking at this benefit, wartime pension or aid and attendance benefit, if you were in country, you could have served as early as 1955, November 1st of 55, up through May of 75. That's if you're in country. And that would also include blue water veterans. So Navy, as long as you were within 2 miles of the coast of the Republic of Vietnam, you would also qualify. Otherwise, the period for serving anywhere in the period runs from 1964 through May of 75. So those are the wartime periods. They do get adjusted every once in a while. We did extend the in-country period just a couple of years ago. If we got the military service, the active duty status, and we got the wartime period, all of those circumstances are what qualify you for the benefit that, as you can see, is a three-tiered benefit. You start out at a base pension. Then you could move up to either homebound status or you could have full aid and attendance. Now, what that means to us at a practical level is every veteran age 65 years old and older is qualified. The VA regs state that at age 65, you are considered disabled. That's not a comforting feeling, but in this case, at age 65, because of age, you're considered disabled and therefore you're eligible for the base pension amount. I'll talk about that in just a minute, what that actually means in terms of the cash payout. Or you can go up in levels. Now, when you go up in levels, that simply increases the payout by a few $100s. So base pension is going to be 1,400 and change. Then you're going to go up to the homebound amount of 1,700. Aid and attendance takes you all the way up to 2,300 and some change. Plus, there's an add-on if you have a spouse or a dependent. So you could qualify married couple, veterans alive with aid and attendance for $2,795. Now, that's important because most every veteran I've ever met knows what service-connected disability is. Service-connected disability, if you receive a 90% disabled rating, you're only going to be receiving around 2025, it's $2,297. So $2,300 if you're 90% disabled. And so many vets will go out and they'll try to file and disability on my shoulder, my knee, my back, my hearing, whatever else it is, so we can continue to increase our rating. You almost never get to above 90% doing that. So pension is going to pay you $400 a month more than a 90% service connected disability. Now, if you can get 70, 80, 90% service connected and add on unemployability, you're going to get paid more because you're going to get paid at 100%, even though you're only 70% disabled. But if you can't get to those higher levels, or you're still working, and there's no way that I'm going to get unemployability, then do pension. And you can always change over later on. The pension is going to be a higher payout. Now, I've talked about the military eligibility standard, active, all of that, serving in a wartime period. Then we talk about the qualifications for base pension at 65 or higher levels, and I'll get to what aid in attendance means. But there's also a financial requirement. So the financial requirement is the VA wants to look at your income and your assets as well as any prior transfers. Now, if you are familiar with Medicaid long-term benefit, where it has a 5-year look back, VA does not have a 5-year look back. It has a 3-year look back. And we can talk about that a bit in just a second. But that's why they're looking at prior transfers. There is an asset standard, which is very simply, you can have net worth of $159,000 and still qualify. And VA does not count your home and the immediate 2 acres around it. Now, what if I have 8 acres? Well, they exclude my home and the first 2 acres, and then we have to do the calculation or get a PVA assessment of what the per acre value is of the remaining 6 acres. And then that goes toward your net worth. VA won't count things when it comes to your assets like a funeral plan, personal property, a personal vehicle. If you have multiple vehicles, they will start counting them. Assets that are excluded in an irrevocable trust are not counted. Now, you might run afoul of the 3-year look back, but we could have been looking at a net worth of several $1,000,000, placed it in trust 3 years ago, and currently qualify because these assets here are not counted. So the net worth, 159,000, is an important number. But for most folks, we don't have, on average, a retired couple, when we hit age 65, 70, they have less than $120,000. So the VA is pretty flexible for us here. The other part of that is not only are they flexible on the net worth limit, they also allow various types of transfers. So we're going to be thinking trust-based asset protection and still qualify for this benefit. So 159 is not hard to qualify for, and no matter how much you have, if we're willing to wait a 3-year period, you can get this benefit. So let's talk about how much we're talking, and then we'll come back to the income standard in just a moment. So base pension, age 65, everyone is qualified for the $1,413 a month. Now, you see that it does, my chart here is a little clumsy. It's got too much on it, but you'll see that you can go up by adding a dependent. So one dependent would take us up to $1,851. Homebound status up to $1,700. My 2 columns are just saying, well, if that's the monthly amount on the right, then how much does that actually give me annually on the left? It's all the way to the bottom. So we have 8 in attendance with 1 dependent, married couple, right? $2,795. That's $33,000 new income every single year. And once you qualify, you continue to receive that for life unless you replace it with another benefit. The VA is always willing to pay you the higher of anything you qualify for. So this $2,795 again is more money in the payout than even excuse me, a 90% service connected disability. So it's smarter to go this way for most people. but people sometimes don't want to do the financial planning necessary to go through this. The second thing about this is this benefit, unlike service-connected disability, is also available to the spouse. Service-connected disability, the injured uh, veteran passes away, benefit goes away. Under some circumstances, your spouse might still qualify for DIC, which stands for Dependent Indemnity Compensation, since you died because of the service-connected disability. And that doesn't say I have cancer due to Agent Orange exposure, right? My wife can qualify for DIC, but the DIC payment's less than $250 monthly. Whereas the spousal benefit under pension, base level $949, but it goes all the way up to $1,515 per month. And in many cases, a surviving spouse, particularly a female, if she had time out of the workforce to raise children, anything like that, this is going to double many people's income. It's going to be as much as their Social Security. So it's a really, really good benefit that many people weren't even aware that existed. So let's go back and let's talk about the income standards for just a moment. So kind of catching up, done 159,000, or we've planned for them in some other ways. But what about income? The income is calculated in a very VA kind of way. The VA takes your base income from all sources. So if you're receiving annuity payments or required minimum distributions of a 401k, IRA, something like that, your Social Security, your retirement pension from, let's say, teaching or from Teamsters or wherever, all of that income, you and your spouse, it's full household income. Then the VA says subtract from that total household income your UMEs. That stands for unreimbursed medical expenses. Now, what are those? Well, your Social Security or Medicare premium, the $170 they keep out, that counts. If you have a Medicare supplement, that counts. Any of your prescription co-pays, if you've got a deductible that you have to pay annually on your supplement, all of those costs, those count as well. So you take all of those expenses. The VA actually is not a backward-looking benefit, it's a forward-looking benefit. So if you can forecast that you have expenses over the next 12 months, then those get counted. And when you subtract the unreimbursed medicals from the income, you come up with a new number called an IVAP, which simply stands for income for VA purposes. So let's just work this. Let's say I got Social Security at $2,500 a month. I've got a Medicare premium that's pretty small, and my deduction, everything that I pay out of pocket for not life insurance, not housing bills, nothing else, just medical expenses, comes to $300. So do the math. That gives me an IVAP of $2,200. If your IVAP is less than the maximum benefit for which you are qualified, so let's say I'm a single, I qualify for 2358. My IVAP is less than that, so I qualify for the difference. So in this case, I'd qualify for what? $158. So that's why when I show up at the VA and talk to them and they say, blah, 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 how do I make? They often will tell all of my veteran clients, oh, you make too much, because with my Social Security, my spouse's security, my unreimbursed medicals are not that high to completely offset my income. Therefore, I don't qualify. The problem is that's not all there is to it. If you were to use a trust-based plan and healthcare contracts, I can create an IVAP that will qualify you for the total benefit. We simply have to take this will be personal income, and this is what we'll go into depth on in our next one together. All of my $2,500, if I'm paying it through a healthcare contract, even though it may be accumulating for me in trust, it still is available to me to use for any expense I have. So that healthcare contract allows me to get 100% of the VA benefit and still have access to my money for any expense I need. But I do have to use those legal tools. That's why when you go to the VA hospital or you're going to DAV or VFW or whomever, that rep there that can't help you, they're not an attorney, so they just tell you you don't qualify and go on your way, please. So you do have to go see a lawyer. You do have to go through a process, and we will go through more of that next time. But you can see there is a way to create UMEs. Anyone can qualify for this benefit. The maximum wait would be 3 years in most cases, not a 3-year wait at all. If you need to ask some more questions before you commit to something, I understand that too. So just let us know. Glad you were here.